Hello. So far we have discussed offer, concept of offer, modes of offer, and types of offer. Let us discuss legal rules for offer. First legal rule as to offer is every proposal must be communicated. The definition of the proposal, as we have earlier seen, noted. It begins with words when one person signifies to another. That is to say, a proposal must be communicated. Significance here means signification of willingness. When one person he signifies his willingness to do something, that is known as offer. An offer to be complete must be communicated to the person to whom it is made. Unless an offer is communicated to the offeree by the offerer or by his authorized agent, there can be no acceptance. A proposal can be accepted only when it comes to the knowledge of the person to whom it is intended to be made. Section 4 therefore provides that the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. That means here when a proposal is made, it must be communicated to the person to whom it is made. For example, if A has made a proposal to B, here it must be communicated to B. Reference may be made here to well-known case Lalman Shukla versus Gauri Dutt. G sent his servant L in search of his missing nephew. G then announced a reward for information concerning the boy. L traced the boy. L, he was a servant. He traced the boy in ignorance of any such announcement or in ignorance of any such offer which is made by his master. Subsequently, when he came to know of this reward, he claimed it. It was held by the court that he was not entitled to the reward. Second rule as to offer, the proposal must be made with a view to create legal relationship. That is intention to create a contract or intention to create a legal relationship. An offer to be enforceable, it must create legal relations. An offer for a social or moral act is no offer. For example, if A invites B, his friend, for lunch and fail to arrange the same, B cannot sue A. B cannot sue A as it does not create legal obligation because this was a mere social agreement between the two friends and therefore it does not give rise to any legal relation. And on the same point, the relevant case law on this point is Belfer versus Belfer. That already we have discussed while discussing elements of valid contract. The third legal rule for offer is the terms of the offer must be definite, clear, and certain. The terms of the offer must be clear and certain, and it must not be vague or ambiguous. If the terms of an offer are vague or indefinite, its acceptance cannot create any contractual relationship. In India, Section 29 of Contract Act provides an agreement the meaning of which is uncertain or not capable of being certain are void, and therefore the terms of the offer must be definite or certain. For example, X offers to sell 100 tons of oil. Here, the offer is not clear. If he is a trader of oil and he said, if he is a trader of oil, so what kind of oil it was intended by the offerer, that is not clear, and therefore here it does not amount to contract, because here the terms of the offer are not definite or certain. So here, if the he has offered to sell 100 tons of oil, in that case which kind of oil he has not mentioned, groundnut oil or sunflower oil or coconut oil, it is not mentioned in the offer, and therefore the offer is not clear or certain or definite, and therefore it becomes void. To constitute a valid agreement, it is essential that the proposal must be certain, that the rights and obligations of the parties arising out of the contract can exactly fixed. A vague offer does not convey what it exactly means, and therefore it will be difficult for the party to perform the contract, and therefore the terms of the offer must be clear or certain. The fourth legal rule as to offer is offer must be made with view to obtaining the assent. Assent here means sammati, or you can say consent. An offer must be addressed to another person with a view to obtaining his assent thereto, and thereby creating legal relationship between them. A person he cannot make an offer to himself, and therefore it must be offer must be addressed to another person. When it is made merely with the view to disclosing the intention of making offer, or is made for soliciting an information, it is not an offer. So offer must be made with a view to obtaining the assent. For example, if I say I intend to sell this, but here if there is no intention of making any such offer, it will not amount to agreement. It will not amount to an offer. Number five, offer should not contain a term or condition, the non compliance of which may be assumed to amount to acceptance. So, thus, a man cannot say that if acceptance is not communicated by a certain time, the offer would be considered as accepted. Means here, offerer cannot say that if you have not answered or communicated any reply, I will assume that you have accepted the offer. So the offer should not contain any such term or condition, the non-compliance of which may be assumed to amount to acceptance. For example, where A writes to B, I will sell you my horse for rupees 5,000, and if you do not reply within 8 days or within 15 days, I shall assume you have accepted the offer. So there is no contract if B does not reply. B is under no obligation to speak. Sixth rule as to offer, the offer must be general or specific. An offer is said to be specific or definite when it is made to a definite person or definite class of person. For example, A offers to sell his motor car to B. So this offer is intended to B, and this is a specific or a definite offer. When an offer is made not to a definite person or definite class of person, but to the world at large or public at large, such an offer is said to be general offer. For example, a, a person who loses his diamond ring offers by advertisement a reward of rupees 1000 to anyone who will bring the ring. So this is said to be a general offer or public offer. So public offer or general offer can be accepted by any person. Legal rule as to offer. Number 7, offer may be expressed or implied. Already I have explained this earlier. An offer may be expressed or implied. If the offer is made by words of mouth, it is called express offer. If the words are spoken, it is called oral offer. If the words are written, it is called written offer. In case no words are used but the offer is derived from the conduct of the parties, it is called implied offer. Whether it is expressed or implied, it is valid. It may be oral or it may be written. 8 rule as to legal offer. Proposal may be conditional. The proposer may prescribe certain conditions in the proposal. Means he may put certain condition in his proposal. The proposer or the offerer may even prescribe the mode of acceptance. For example, he may expect that the acceptor or the proposee should write a letter or email to him. So, if the mode is prescribed, in that case, uh, the proposee or acceptor must reply in the prescribed mode. It will be valid acceptance only when such proposal is accepted with the conditions prescribed in the proposal. For example, X agreed to buy automatic machine from Y and sign an order in order form given by Y containing a number of clauses in small print. So without reading them, he accepted the offer. It was held that the clauses were binding. Number 9, the proposal may be positive or negative. A proposal may be to do something or not to do something. A proposal to do something is a positive proposal. For example, A says to B, I will sell my house for rupees 1 lakh. This is a positive proposal. A proposal not to do something is a negative proposal. Example, if a director agrees to sign a particular actor if he did not sign any other film. So this is negative offer. Number 10, an offer may be distinguished from a declaration of intention and an announcement. A declaration by a person that he intends to do something gives no right of action to another. Such declaration only means that an offer will be made or invited in future and not that an offer is made now. So mere declaration of intention does not constitute an offer. An advertisement for concert or an auction sale does not amount to offer. Second, an offer is also distinguished from invitation to offer. So, invitation to make an offer is no offer. An offer must further be distinguished from an intention to make an offer. Thus, display of goods by shopkeeper in his window with price marked on them is not an offer but merely an invitation to make the public to make an offer to buy the goods at the marked price. So the display of article with price on it in a shop window is merely an invitation to treat or invitation to offer. It is no offer. Likewise, quotations, catalog, advertisement in newspaper for sale of an article or circulars sent to potential customer do not constitute an offer. They are instead an invitation to the public to make an offer. However, an exception has been made in case of general offer of reward to the public. For example, a advertises in the Times of India that he would pay rupees 100 to anyone who found and returned her lost purse. So this is an offer. So a newspaper advertisement for reward is an exception to invitation to offer. Offer and invitation to offer. Offer signifies intention or willingness to enter into contract, whereas invitation to offer does not signify such intention. It is made to get acceptance. Offer is made to get acceptance, whereas invitation to offer is to get offer. Offer gives rise to legal consequences, whereas invitation to offer does not give rise to legal consequences. Harvey versus Facey case law, which is on mere statement of price and an offer does not amount to an offer, I will be discussing in the next video.